have, sort of organized. And we are thankful to the I4 Mentor Foundation for, stepping up with us in collaboration to, hold these webinars for our members and for the general public also, because this is an open webinar. This is the second in the series, as I told you, of the webinars. The first one was a great success, and we got some very good feedback for it, and we are still getting it. And the second one is on protecting and commercializing innovation and introduction to intellectual property and patents management. We have a very interesting lineup of speakers for this session. But even before I say anything else, or I introduce the speakers and the subject in general, I would request our President, Dr. Hemchandra, to please address the participants as to the aim and the function of these webinars and what AHA is doing. Over to you, Dr. Hem.
Thank you, sir. Thank you very much. A very good afternoon to all of you. And it's nice to meet every time the new speakers from the I4 Mentors Foundation. And this is the second webinar of the series, and we are quite happy that gradually people have started joining this particular program. And from the next time, I think we'll make it more and more interesting by giving the information in time and personal meeting. And the subject chosen this time is a very, very useful for the basically, and it is connected with the administrative and research and the other aspects also. And the patent is a very important aspect, and the intellectual property. That is basically nowadays, if you in the field of research especially, and we in the hospital or the healthcare administration research, it is very useful for everybody. So I think the students next time we will also encourage the student group to go forward, because conversely people do not want to join nowadays. Reason being, basically they do not understand the actual meaning or the actual outcome of that particular webinar. So I'm very happy that we have two speakers today. I was just going through this app, downloaded now to print before me basically the CV of both the speakers, and I congratulate both of them, and especially our team and the program director and the Shama and the General Jagtar Singh for having chosen this much of profile. Basically, I have come very little bit across the such type of the people in life, and both of them are really outstanding, and I think everybody will be benefited out of this program. And now it shows that the academy now gradually moving towards the away, and gradually, in addition to our earlier programs, we are also going to the outreach in the direction of the research and teaching, training and programs, by having the collaboration with the good reputed companies like the I4 and Mentors Foundation. And I most welcome on behalf of the Academy of Hospital Administration. I really extend warm welcome to Dr. P. Somarajan and the Madam S. Kiran, Botham, and the Dr. Rajveer Singh Sahab jo hain. And my respected audience, delegates, those who are present today and will be joining very soon gradually, and I hope all of them, they will be benefited. Thank you very much, sir. Without taking any time, I think let's go ahead. Thank you very much for your kind appearance, sir, and accepted our invitation for this program today, and hope that this the chain of that will be strengthened for forever in near future also. Thank you very much. Thank you. Oscar.
Thank you, Dr. Hem, for your kind words. Just to lay the framework for this webinar, we would have the two speakers in this webinar. That is Mr. P. Somarajan and Miss S. Kiran, right? And they will follow me after the introductory remarks. Then we are going to have a question answer session in the last 15 minutes. This program is actually scheduled for about an hour, so we would be trying to stick to that time. However, during Ms. S. Kiran's session, she would be interacting with the audience and the participants, and she would be inviting certain, questions and queries. So please be free to, sort of participate in the manner that she would envisage in her presentation. So that is as far as the presentation part is concerned. Then in the end, Dr. Rajveer Singh, who was the director of the I4 Mentor Foundation, he would be announcing a contest for the members, our AHA members. And that would be a very interesting sidelight of how contest for innovative ideas and for startups he has conceptualized for us, and he would be talking about that. So not taking more time, I'll just launch off into the webinar per se. What I would like to say is that everyone has ideas. There could be good ideas, there can be bad ideas, there can be naughty ideas, there can be funny ideas, there can be serious ideas, there can be creative ideas, and there can be innovative ideas. But what is important in the world today, as all of you would agree, is that the ideas should not just remain ideas, they should make you money. They can let you earn. That's important. And that is why these ideas become very, very precious. And if they are precious, they need to be protected. Well, that is the whole idea of today's webinar, right? That we know what our idea is, what an innovative idea is. That's what we saw last time. So this time, as a follow-up, this webinar actually tells you how you can protect your idea or how you can protect your creative endeavor. After all, it's your intellectual property. Just like your physical, financial, whatever property you may call it, this also needs to be protected, and that is what we need to understand. And this understanding, we are very fortunate today that we have two very eminent experts from this field who have got years of experience, and they are going to tell us about how do you manage the intellectual property and you manage the patents. They will make us understand that. And to talk about it initially would be Mr. P. Somarajan. He is an engineer by profession and then a management expert from IIM Bangalore. He's done his engineering from IIT Delhi. He's got a vast experience as far as the industrial sector is concerned, and is presently the CEO of the Atal Incubation Center of IIT Delhi, right at their Sonipat campus. And then also he is in the senior management of the Foundation for Innovation of Technology Transfer at IIT Delhi. This organization has been in the forefront of translating the ideas or the innovative products into the market, getting it, into the commercial side of the whole game of innovation and startups. So we are very fortunate to have you. Welcome, Soma. So it'll be good to hear you. Also giving him company is Ms. S. Kiran. She is also with the Foundation of Innovation and Technology Transfer. She is expert as far as the patent management is concerned. And she is actually going to give us an insight of how this aspect, after you have had an idea and you want to sort of patent it and get a copyright of it, how do you do it? And she is going to tell us the various steps and what is involved in it. So, without wasting much more time, over to you, Soma, so that you can continue with the rest of the webinar. The field is yours. We are all ears. Thank you.
Thank you so much. Actually, you have taken away most of my words, but yeah, yeah. Actually, the bedrock of human civilization is the creativity of the human intellect, and it is the human intellect that has created so much that we see as progress in the human life. So, whether it is an idea of a machine or a tool or a song or a written poetry or a literature, any of these is the output of a creative mind. And these creative outputs have to be protected so that the creator can make a living out of it or money out of it. Otherwise, nobody would want to create new things. So, creativity, of course, progresses the human civilization and gives it. It has taken us. We have reached where we have reached because of all the creativity that the human mind could come out with, and we are still doing new things. So, intellectual property is the creative output of the human intellect. Now, this is like any other property, whether it be land, gold, money, any other kind of property. It is a property. So all intellectual property you have the same rights on it like you have with other rights. These can be registered in your name. These can be sold. These can be licensed. These can be rent. These can be stolen. So anything can happen. It's exactly like any other property, and you have to have the rights to. You have to have the rights to it legally. You can get the rights to it. So those rights are called, of course, come in various types, whether it is patents or copyrights or trademarks or all these are various intellectual property rights. So Kiran will be explaining more about it. Both Kiran and I were I was at FIT. Now I'm not regular with them, so they do call me sometimes to help them out. But Kiran is still with FIT. FIT is the corporate interface of IIT. The technological developments of IIT has to be made available to the industry for taking it further for the benefit of the society. So FIT is the keeper of all the patents and one of the verticals that FIT looks after is the patent filing and patent portfolio management. So Kiran is part of that, and she has many years of experience doing that, file over hundreds of patents every year, so her experience is vast. I would urge all your members to learn from what she has to say, and I'm sure this one session may not be enough. We are willing to have maybe another session also, just laying out the background so that Kiran can be ready for another one if required. So now I will hand over the baton to Kiran. She will take over and explain in detail about patents and how to manage another intellectual property. Thank you, Kiran.
Thank you. Thank you, Somarajan sir, for such a beautiful introduction of IP and about me. And thank you, organizers of AHA and all the team for arranging this session and inviting me for this prestigious organization as a speaker. Thank you so much. So I'll now begin with the session and we'll try to accommodate as much information as possible so that you get an idea after the session what exactly is an intellectual property and how it could be explored further. So I'll be just sharing my screen. Yeah, is my screen visible?
Yes.
Is my screen visible?
Kiran.
Am I audible?
Yeah, Kiran, you are audible.
Thank you. So I would urge the participants to kindly unmute their mic whenever they feel like answering the questions, because in between I have put some questions, and even at the later stage also I have some MCQs which they could answer, and I want each and everyone to participate. So this is about protecting and commercializing innovation, introduction to intellectual property and patents management. So in this session, I would particularly cover about the intellectual property, what exactly it is and what all can be protected and what should not be protected. The value of an idea lies in using it. So this is what Professor Jagtar and Somarajan sir were saying, that if you have an idea, you have to put it into practice and then earn a lot of money out of it. Right? So that is what Thomas Edison has said about his improvement in the bulb electric lamps, which he has patented in 1880, January 27th, 1880. So what do we do at FITT? First, I would give a small brief about what do we do at FITT regarding the intellectual property management and technology transfer. We help in inter-institutional academic collaborations like industry mapping, linkages, marketing, etc. We try and help companies and industries to identify potential technologies and collaborate with them for research as well as protections. We schedule and arrange for IPR awareness sessions wherein we try to sensitize the whole country at various regions. We have an regional ITTO office also. Other than IIT Delhi, we help other startups and companies how to protect IP and how they should approach as a startup or as a company to protect their innovation. We help in IP filings and managements like patent search, analytics, facilitating drafting, filing, prosecution, maintenance, IP audits, and documentations. We help in technology transfer and licensing, like we help in technology valuation. Once the IP is filed, what is to be done? It has to be translated. So we provide a proper steps or procedure, how it should be transferred, at what stage is your technology, how it should be taken up from level 3 to level 7. What are the steps to include monetize your technology into a market level product. We help in academic spin-offs. We help in legal support like drafting of IP policies, like agreements, SOPs, and various collaborations and consultancies. To begin with, the definition of intellectual property. What is an intellectual property? The term itself says intellectual property is the creation of mind. What does that mean? Something that comes out of your intellect. That is creation of mind. It could be either an invention, it could be either an artistic work, a painting, an article, a book, or a sculpture. Anything that is artistic in nature can also be protected. Literary work, that is poem, novels, songs, musical works like songs, and compositions, and brand names, logos, word marks, all this fall under intellectual properties. Because all of these have intellect, human intellect being used in them. That is why they are called intellectual property. The rights associated with these properties are called intellectual property rights. Okay. What are these? How many types of intellectual properties are there? So it is not only patents that falls under or is called an innovation or intellectual property. Of course, patent is the most vast and elaborative form of intellectual property, but there are other forms of intellectual properties also. One of them is patents, copyrights, trademarks, designs, trade secrets, geographical indications, semiconductor layout, and plant variety protection. These are as per the Indian law. There is one thing that is not mentioned in the Indian law, only the term is there, that is trade secrets. But there is no particular regime in India for protecting anything under the trade secret. So if you ask for me for a process to protect a trade secret, there is nothing as such as of now. So trade secrets and know-how fall outside the scope of protection under the current IP regime of India, and they are there to safeguard under the general laws. Anyone with confidential information should also sign the non-disclosure agreements. So trade secrets ka abhi as such, there is no procedure for protection. What is the benefit? Why should I protect my intellectual property? The benefits is, what does it do? It will motivate one person to and encourage him to have more research work. It will reward the patent holders. It will help in generation of revenues through mode of transfer. Ultimately, if you innovate something, that will be for the benefit of the society. The better the innovation is, the better societal benefit would be. Indian law has provided certain reduced fee provisions for academia, startups, MSMEs. One can avail that. And it helps in building a brand value. It helps in building a reputation and quality. It encourages particular collaborations with various organizations also. How do we manage intellectual property? Once we create an idea or a research, we conduct IP searches and assessments. Then, once the assessments are done, we can strategize under which type of IP it could be protected. Whether it should be filed as a patent application, whether it should be filed as a trademark or a design, that could be decided based on the idea that you have created. Then once it is created, we try to secure it. How do we secure it? We try to file it through some patent agent or a law firm, or by other means. The IP protection has to be secured at the Government of India Patent Office. And if we have multiple such ideas, we can have a portfolio of them and have an umbrella of IP under our ownership. There are certain things that you need to take care before filing of an IP, such as signing of confidential agreements, MOUs, employee contracts, and collaborations. We also look into IP enforcement and defense, how it should be enforced and how it should be stopped others from copying it or infringing it. The transfer and use of IP through licensing agreements should also be taken care of. So generally, it is suggested an institute or company must have an IPR policy as per the guidelines of the National IP Policy of India. This helps the institutes and companies to navigate the complex landscape of intellectual property. This will protect their innovations and creations and ensure compliance with relevant laws and regulations. So what are the differences between these different terms like patent, trademark, copyright, design? These are the 4 types of IP which are generally in use, such as patent protects the technical part of anything, technology part of anything, like it can be a product or a process or both. Whereas a trademark protects a logo, like a graphical design or a tagline. You can have a word mark or a tagline that could be protected under a trademark type of IP. Copyright covers mostly if an algorithm has been developed, a software has been developed, or musical works, artistic works, you have written a paper to be published, that could fall under copyright protection. And design protects the aesthetic look and feel of a product. Suppose you have designed a pen, which is very beautiful in shape, has a very zigzag shape, but other pens also exist in the market. but the shape of your pen is totally different. That falls under a design application. And what are the different types of criteria for an IP to fall under? How do I identify where should it go? I have developed an innovation. Now I don't know whether I should file it as a copyright, as a design, or as a patent. How should I decide it? So there are certain criteria. Like for a patent, there are 3 criteria. It should be novel. What does novelty mean? Novelty means it should not be published anywhere before the date of disclosure in a patent application. We will discuss it in detail in the coming slides. But novelty is it has not been disclosed anywhere before the date. Non-obvious means non-obviousness is also called inventive step. It has a particular advantage or has a unique feature, has a USP over other products or processes that are already existing in the public domain. That is non-obviousness. Third is industrial application. Industrial application means it should have a benefit to the society. It should be applicable in a practical world where the industry can utilize it, manufacture it, and sell it to the public. So that is the criteria for patent application. For trademark, it should be distinctive and non-deceptive. That is the basic criteria for trademark. Copyright, any original work that has come as an expression of idea is a copyrightable subject matter. And for a design registration, it should be new and original. How does it differ from copyright? For a design also, the criteria of novelty is mandatory. But for a copyright, novelty is not mandatory. Originality is mandatory. Okay. So there is a lifetime of all these protections. One cannot have forever protection on anything. So the term of a patent application is 20 years from the date of its existence, 20 years from the date of its first filing. Second is trademark. Trademark, the life of trademark is 10 years and it is further renewable for every 5 years. Same goes with copyright application. Copyright is the one which has a whole lifetime protection of the author and 50 to 60 years further on it. Design protection has a term of 10 years and it is renewable for 5 more years. Now, the detail about a patent is it is a techno-legal document. You have a product or a process, but how do we protect it? You cannot just submit that product somewhere and then have a protection. It has to be in a document form. So it is a technology crafted as a legal document and then protected as a patent application. It is an exclusive right. Its term is 20 years. It is territorial in nature. Territorial in nature means something that is protected in India can be ensured to be protected in India only. If you want to have it outside of India, then you have to file it in that particular country where you have the fear or a competition in. That particular country, your patent application has to be secured in. So these IP rights are territorial in nature. The criteria we have just discussed: novelty, inventive step, and industrial applicability or usability. So the pin which you are seeing here, the paper clip, that is a basic clip. We all use it for day-to-day lives, in our day-to-day lives, as well as a safety pin, which you are all are using. Mostly females use it. So these are patented subject matters. People have IP rights over it. And those people still get royalty and revenue out of it. Although the term of a patent has expired, but as per their contracts or their licensing terms, they may be getting royalties on it still because they have been taken over by companies. So these are some of the examples that for the IP that has been filed at IIT Delhi through FITT. At the time of COVID pandemic, we have developed RT-PCR testing kits. The researchers at IIT Delhi, they have developed it and they have also been licensed at that time for production and selling. Rapid antigen kits were sold. N95 masks at low cost were prepared and sold. PPE kits, alcohol-free sanitizers were prepared. All of these, for these, IP has been already secured and owned by IIT Delhi. There are some technologies that have also been licensed to to various companies like Smart Cane. They have prepared easy mobility for visually challenged people. This is a stick which has a sensor in it, that travel aid which fits on top fold of the white cane. This users can diagnose anything above the knee obstruction from a distance of 3 meters. This was a project from Assisted Labs. This was a student's project at IIT Delhi. And the patent application first was filed in 2007. Another example is robo-exoskeleton. This is a device for upper limb rehabilitation. So they have protected the device under patent protection, and the one which you are seeing, robo-exosmart, is a trademark application also. The logo is a trademark and the device is a patent application. What is a copyright? Copyright, as we have recently discussed, it is an original, literary, dramatic, musical, and artistic work. It also includes cinematographic films, sound recordings, and software programs, source code, algorithms. All these fall under the literary part of the copyright application. So the term of the copyright application would be the life of the author plus 50-60 years. The criteria is again originality of the work. I just wanted to include some examples here, like an algorithm for controlling the closed group rehabilitation device is the copyright application. File compression and decompression of polar codes is another copyright application of IIT Delhi. Underwater acoustic communication link is the example of copyright that was filed. So there were algorithms, source codes, and programs here. Trademarks is a visually appearing symbol or a word, which is capable of graphical representation. This should be able to differentiate goods and services from one another of different companies. What does it build? Basically, once we see a logo of Coca-Cola, what do we know? It is a brand and it has a reputation associated with it. We know that branded clothes are more reliable as compared to normal clothes. How do we know that? How do we differentiate it? By the brand value. How do we establish the brand value? By looking at the logo of that company. Industrial designs are the aesthetic look and feel of a product. They should be new and original, such as one of the examples of IIT Delhi is reusable sanitary pads. So they have designed the sanitary pad which is reusable and which has a very novel structure of it, very novel look of it. So that was protected under the design application. Similarly, for interactive braille learning, the researchers at IIT Delhi have developed a product for interactive braille learning. So that was protected under design registration because there may not be technology that is there, novel, but there is a novel design that has helped many to overcome the previous problems. This is another type of IP. This is a geographical indication just to identify and establish the geographical famous things. Like we all know, Tirupati Laddu is from Tirupati and a famous product at Tirupati, and one that has this registry will be the authorized person or an authorized company to sell that product. So like this, the producers and the local local people there who are working on that particular area will get benefit of the revenue generated. So this indicates the unique nature and reputation of that particular product. So we all love Darjeeling tea, but there are many Darjeeling teas which are fake. So the ones that have this logo is the correct and authentic Darjeeling tea. That is how one can identify it. So it is initially valid for a period of 10 years. This is another form of IP. Here the semiconductors which were originally designed and distinctive from the other semiconductors could be filed and protected under semiconductor design. The question comes, how do I protect all of these? These are various types of IPs. How do I protect them? So here is a small brief of the process that is followed for IP filing and processing. The first one is initiation. What is initiation? It is first you have to disclose your technology. Disclosure means you have to put it into writing. That what is my technology? How is it different from others? What is the problem statement that I am able to solve? What is existing already in the public domain? And how is mine different from what is existing? All three questions, if you are able to answer, you are able to put it into writing, that becomes your first initial disclosure of the invention. Once you are able to do that, you can connect with the IP team or coordinator or somebody at your institute to discuss further that what is the next level. The disclosure will go under assessment by the IP cell or whose IP team member for assessment. They will advise you what should be done with this disclosure. Whether you should go for filing of patent or a copyright or a trademark or a design, that will help. They will also perform a prior art search at their level and share that with you that, see, these are the similar innovations that are already available in the public domain. Are you able to differentiate your invention from them or not? So if so, you can try to provide a rebuttal to that and proceed further for the next step. The steps from filing to renewal are handled at the end of patent office. Once you file the application, here you would require a patent agent or a law firm or somebody who would help you draft the document in a legal format, because technology you have disclosed. Legalities, the law firm or a patent agent would see, verify, and then file it at the patent office. Once it is filed at the patent office, you will secure the application number and priority date. What is the priority date? That is the first filing date. It is not the date when you have initiated the disclosure. This will be considered as your first date of securing. Then it will be eventually examined by the patent office. And then if all the rebuttal or if the patent office feels satisfied, it is granted by the patent office. Once it is granted, it is the responsibility of the patent owner or IP owner to get it renewed from time to time based on the relevancy of that technology. Means if the technology is almost 15 years old and you do not see any potential in the market because new technologies have taken over and the previous technologies is no longer any relevant, you may discontinue renewing it after 15 years. Or at the 10th year, you can decide, or at the 5th year, you can decide what is the current market value of my product, whether I should maintain it or not. Like this, we can decide how to renew our patent, whether to renew our patent or any other IP or not. We have in-house patent agents and technical experts to help you with this. So for any detailed IP process and disclosure forms, you can also visit our website, wherein we have elaborately mentioned all the steps that we follow at FITT. Now I have a question for the participants. Who owns the intellectual properties that is generated by me? Here, me is you yourself. Please feel free to answer. I will give you 10 seconds. Anybody from A, B, C? Who owns the IP? Please try to give wrong answers also.
B.
B, one who has created.
Yeah.
Okay. Anyone has any other answer?
Company and organization.
Okay. Okay. So in a way, I would say both are correct. But the correct answer to this is company and organization if you are associated with the company and organization. So I'll give you an example. So you are working with AHA. Suppose you are one of the students or employees at AHA. You have developed a new medical device. You have developed a new medical device Now that medical device, who owns that medical device? Whether your company or you yourself. Of course, you have developed, you should own it. But in a patent application, there are two things that are to be kept in mind. One is ownership, one is inventorship. If you have developed that device with the resources of the company or organization or under your employment with your organization, by default, your organization owns it because your affiliation is with your organization. If your organization decides you can go ahead in your individual capacity and file it in your own, yes, you can own it and be the inventor at the same time. But if your organization says, no, this is the property of the organization and organization will own it, in that case, your organization must own it and you will be one of the inventors. Of course, if it is commercialized at a later stage, you will get the benefits as per the policy of the institute of the revenue that is generated. But the ownership would belong to the organization and company. But let us say if you have if you have written a song out of the scope of your job profile, at your work hours, at your home, in your free time, at that time you can own that IP because that is out of the scope of your work, out of the scope of your organization's work, and that is your own creative work. Like you have made a painting, you have written a song, that way, in that case, you will be the owner, you will be the author. But in the first scenario, you will be the inventor only and not the owner. Okay. Thank you for your responses. I have more questions. Where is my innovation protected? Now somebody has developed a medical device. Where is that protected? And can I have a worldwide protection?
Yes.
No, it can't be worldwide. It will be in the area that I have done the innovation.
That's right. And where is it protected? In the area that you have protected.
That is the territory, that is the country maybe.
Correct, correct. That is exactly correct. So these rights are territorial. Like we have mentioned before, these are territorial rights. If you want to have a protection in more than one country, there is an option. But of all the 190 plus countries that we have in the world, it is very difficult for one to get your IP secured in all the 190 plus countries because they may not have the same laws and provisions first, and secondly, there will be no use of doing so much of expenses when there is no competition and that product may not have the relevance in all the 190 plus countries. So if the product has first developed in India, you should first file it in India. If the Indian Patent Office says, as per the law, Indian law, it is not patentable in India, then also you have to seek permission from the Indian Patent Office to file it anywhere other than India. There is a provision of filing PCT. PCT is a Patent Corporation Treaty or a convention application, which gives you a timeline of filing the same application which was filed in India within 12 months from the date of filing the first application. Okay, that is the provision of PCT. No, I do not want to go for PCT. PCT is a window. So that is a window where 150 countries have signed a treaty where they can enter for a limited time period. It will give you a search advice that this is our opinion. Based on that, you can decide which country to enter. Through PCT, you can buy time and you can save little money if you want willing to enter more than one country. But if you're sure that your market is in India and Europe only, suppose, then it is better to file in India and within 12 months you file in Europe directly. But if you have opted for PCT, you will have more time of 30-31 months to enter the international phase of filing with the same application that was filed in India first. So this is the route which could be followed with the same application that was first filed in India. Okay. Now, there are certain restrictions that the Indian law provides. What are those restrictions and how they are relevant? So anything that falls in the criteria of novelty, inventiveness, and industrial applicability could be filed as a patent application? No. The answer is no. Why no? Because Indian law has certain restrictions, which it says if it falls, even if an application fulfills all these criteria, but it falls in any of these conditions, it will not be protected under the IP law. So what are those conditions? Let us go through them very quickly. Those conditions are if the invention is totally frivolous and contrary to the public order. If I say that sun rises in the west, so it is totally new concept and I can prove it through some algorithm or some logic that yes, it rises in the west. And of course, sun is helpful for all. Sun is of a public benefit. Industrial applicability is also there. Can I get a patent on that? No. Here, under the first law, this inventions being frivolous and contrary to the public order, it will clearly get rejected. Second is scientific.
Can I
Yes.
interject here? Sorry.
Yes.
So if that be the case,
Mhm.
how come US could patent haldi or neem for that matter of fact, or
Yeah,
rice
US
for that matter of fact?
That's right. US has tried filing for patent applications for the wound healing capacities of haldi and tulsi and the rice, which you are saying.
Yeah,
But
even pepper also. Even pepper.
Yeah.
Yeah.
Yeah, it has filed, but it did not get granted. So CSIR has fought these cases for those patent applications, and they were ultimately rejected by the US Patent Office, specifically about the haldi and tulsi ones, because nobody in India thought they could be filed under patent application, because this is the general home remedies which all our grandparents have taught us, or even their grandparents have taught us, and this has come through ages to us. So nobody in India thought of them as writing it and putting it. But CSIR and the Traditional Knowledge Depository Library has pulled out the ancient scriptures where the antibacterial and wound healing properties of haldi and benefits of tulsi were written in Sanskrit. They were translated and fought back in the US, and we have won those cases and they were not granted.
Kiran, can I just interject for a minute?
Yes, sir.
How much time would you be having more? Taking more?
So 5 to 7 minutes.
Yeah, if you can just try to wrap it up.
I'll quickly wind this up. Yeah, I'll quickly wind it up in 5 minutes or so.
Yeah. Thank you.
Thank you, sir. So mere scientific discoveries, like you found a stone, which you are saying that after the periodic table 108 Warner 12 elements, I have found something new and I have discovered something out of the earth. That is also not patentable subject matter in India. Any new form of a known substance. New form of the known substance is very important because one form is already known. Suppose a tablet is known. I am making that tablet into powder. It will not be patentable. Okay. And mere admixtures will also not fall under patentable subject matter. Arrangement, rearrangement. Like saucer on a cup and cup on the saucer. I have just made a rearrangement. This is very basic ones, but people, what they do is they try to change the alignments of things and then come up saying that that is a new invention, but that does not fall under a new invention kind of a criteria. Methods of agriculture and horticulture, these are not patentable in India because India is a developing country and agriculture and horticulture are the main things that India is surviving on. So these methods, any methods of such kind, the Indian law restricts, whereas other countries do allow it, but India restricts such innovations that are related to method of agriculture. Anything method of treatment, suppose a medicinal method or a surgical method of treatment on humans or animals are not patentable. Of course, the medical devices are protectable, medical kits are protectable, but surgical methods or method of treatment, how do we treat it? That is not protected. The process, I mean, that will include the process. How do I do it? A doctor can do a surgery in any method, but he cannot protect the method of doing that surgery. Got it? Plants and animals or biological processes other than microorganisms as such are not patentable. Mathematical methods, business methods, computer methods, or this presentations which I am presenting to you is not a patentable subject matter. That falls under copyright if you have some business method or some algorithms that you have. Literary works, these fall under copyright, so they are also not protectable under patents. Schemes, rules, methodology, something which has mental maths in it, formulas, mental maths, playing games, all those are not protectable. Presentation of information is not protectable. Topology of integrated circuits is also not protectable. Again, the ones which ma'am has asked about the haldi and all, something which is already there in the traditional knowledge and we are well aware of it, and its duplication. After due diligence only, if it does not fall or somewhere one is able to establish that it is not a traditional knowledge merely, only then that could be protectable. So one, while writing, one has to take care of it. You are not putting merely the traditional knowledge as it is in the draft so that it is objected under traditional knowledge clause. Atomic energy related to defense and national security innovations are strictly considered and are not always granted. What are the do's and don'ts? So as soon as you develop an important technology, promptly investigate whether it is to be patentable or not. Before deciding whether to file a patent application, have a patentability search done and consult an IP and TTT. If there is a requirement to disclose your invention outside of your company, then you should have filed either your IP first, your patent application first, and or get a non-disclosure agreement signed first. Because somebody may be your friend, maybe you are known, but if he's outside of the scope of the company and his work is related to yours, he may intend to copy it and work on it at the same time. So better to get a non-disclosure agreement signed at the same time. If your invention is patentable, file your patent application before you disclose it anywhere, even if you are disclosing it as a publication paper, as a demo, or with a third party. Because many countries do not even have a grace period. So let us quickly go through a small quiz. I would request all of you to just give me answers within few seconds. We'll just quickly wind it up in 3 minutes. Okay. There are few questions. Which of the following is not a form of intellectual property right? Patent, trademark, non-disclosure agreement, or a geographical indication?
NDA.
Sorry?
NDA is
D.
Yes. Correct.
Non-disclosure.
Correct. That is the right answer. Non-disclosure agreement is not a form of intellectual property. It comes under the contract, and non-disclosure agreement has to be signed before filing of an IP if any third party is involved or you are disclosing it. What protects the intellectual property created by the innovators? Inventors. In which scenario we have inventors? When we have an invention. When do we have an invention? In copyright, geography.
Patent.
Correct. That is the right answer. Patents is the right answer. In copyright, we have authors. In geographical indications, it is a geography that is related to a geography. In trademarks, it is a company that owns the logo. And in designs, it is also the organization that owns the design or the author. What protects the intellectual property created by the artist?
Copyright.
Design.
Copyright.
Copyright.
Correct. Copyright is the right answer. Which of these is a geographical indication?
Hogwarts. Hogwarts. is
Any more?
Champagne.
Champagne. Yeah.
Champagne is the right answer. Champagne is the right answer because there is a place in France, I believe, where this sparkle wine is included. That to acknowledge that place, this champagne is a geographical indication. What does a trademark protect?
Those names, brands.
Correct. It protects logos, names, and brands. I hope everyone is following it. I am not going too fast, right?
No, it's okay.
Thank you. What is the term of the patent?
20 years.
20 years.
20 years.
That's great. Everyone is following. Which of the following is not eligible for patent protection in India?
Varieties of plants, new varieties of plants.
Yeah, that falls under plant protection, right?
Yeah.
Imagine a sports company sets up a sports team sets up a company to sell its own range of clothes. What type of intellectual property can the team use to show that those clothes are made by them?
Trademark.
Trademarks.
Correct. If a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their invention?
Copyright.
Registered design. Registered design.
Yeah, registered design, right.
Design can also be there, patents can also be there. If it is a new improvement and they are able to establish that new improvement, they can also file it as a patent, as a addition of the previous patent that they have already owned. Okay. Design is about the look. If they have improved the whole look of that, it can be filed under a design application. Now, how many intellectual properties can be possible in this photo? Only see the this area, center area only. What all is there?
3.
Okay, what all are those?
Design, trademark,
Trademark.
Okay, trademark is right. Design is right. Design of
bottles as well
Tagline.
as
Bottle, taglines.
And tagline.
Tagline is a trademark. This name is a trademark. So you can see the name Bisleri with R marked in it. And the sweet taste of purity is a tagline. So this is a trademark. And
color,
the bottle
color
design, yeah,
Color.
the bottle
Color also.
design and its color. Yeah, color falls under trademark only. So if you protect it under black and white, you can use any color. But the main thing is the water composition. If they have added minerals to it to a certain extent in a certain ratio, they may also file a patent application in it. They may be having a patent application also. So the 3 IPs would be trademark, design, and patent.
and they have to be done separately for all the 3.
Yes, they have to be done separately.
The 3 applications has to be filed.
Yes, 3 separate applications would be filed. One as a patent application, which would disclose the innovation part of it, the water composition part of it, the trademark for the logo and the tagline under the class that they are referring to, and the design as a design registration for the look and feel of the bottle, so that one person who is having a Bisleri bottle can be easily differentiated from the person who is having a bottle of Aquafresh or Kinley. So thank you very much. That is all I have for today.
Thank you so much, Kiran. May I now hand it over to our audience for any questions? Any more questions? I think you have asked yourself a lot of questions.
I have asked so many questions.
Yeah.
But I'm very happy with the audience. They have been following throughout and they were very prompt in answering all the questions.
Yeah, I have a question, madam.
Yes.
Madam, request give an example of a process which has been patented.
Process which has been patented. So there are many processes of making a new product in like one pot synthesis. I would say one pot synthesis of a drug. So earlier that drug was made in several steps. It would take 24 hours. Now I have developed a new catalyst or a new temperature range or a parameter which I am able to do it within 2 hours. That process could be patentable. Or if I have developed something which I have changed the reactant and drastically reduced the cost of it, that could be patentable.
And KFC chicken, that is a process patented or The recipe of KFC chicken.
KFC chicken. I
Yeah.
have to check that. I am not aware about what exactly was filed as a patent or as a design, because that is, I think, different spice ingredients they have protected. The recipe they may have protected.
Process, because that the first they boil other things, that could be the process also.
Yeah, that could be a process, but they may not have disclosed it, I believe. I have to check if they have the process patent filed in their name or I'm not aware of that.
Yeah. And one more question, ma'am. The scientific articles that we write down and all that, which get published in index journals, is
Hmm.
copyright automatically granted to them, or we have to file it separately?
So you already give the copyrights to the publishers, right? You sign some documents. You already
Yes, so
have given the copyrights. You are the author, and the publisher takes the copyright about it, and it is already yours. Once you have created it, copyright is yours. The only
Okay.
purpose of having a formally copyright being registered is to sue others if you feel like others have copied it. Otherwise, once it is generated, it is yours. To formally sue
Thank
it
you.
in the court, that copyright filing is required.
Thank you.
Yeah, Major Asim, please go ahead.
Yes, good afternoon, ma'am. I am Major Asim. I am doing my MD in hospital administration at PGI Chandigarh. So, I had a query, in case we are developing some forms for getting
Mhm.
feedback or getting incident reporting, like patient safety incidents. So, should we go for it as a patent or for a copyright if I want to register my form?
You should go for a copyright. So because you have developed a questionnaire kind of a thing, right? Which
Yes.
which is helping you extract data from the people and I analyze it in a simpler way. So better to get the copyright of that questionnaire format.
And how should I go about it, ma'am?
You go to the IP coordinator, or you can write to Professor Jagtar or ma'am, Dr. Ma'am. So they will help you connect with the right people and try to help you as much
Thank
as
you so
possible.
much.
Thank you.
Any question? Any other question?
Ma'am,
I think the kind of interest which is there, with due permission of President, maybe we can have one more session. Hemchandra sir, maybe next time also we can have one more session to address these patent issues in a greater detail. What do you say, sir?
Yeah. It's basically I will just compliment the whole team of the speakers, including the P. Somarajan sir and the Kiran and the organizers also. And after a long period, I will tell you that I could come across such a beautiful way of communication and the importance of the IP basically. And in the day-to-day life, basically, we just say these terminologies, but they have made many differences between among the different types of the IP examples. Now I can understand and I would like to convey to everybody that अब समझ में आना चाहिए कि टाटा बाटा को घाटा क्यों नहीं होता है. These are the reasons basically the trademark. The moment we listen or see that particular trademark and we go with our close eye that I should go to purchase this thing. Similarly, in the cinema, if you see there in the past, basically, Rajashree production, whenever we see that trademark, that though everybody is ready to go with the family to see that pictures, basically. So these are the very, very important. These all IP or they are long-term benefit. They give the return in the long term, basically. And very important. And I think, Dr. Shama, I think we should go for another such type or the similar webinar, those who could not join, because it's a very important and very informative speech basically given by the speakers.
Yes, sir. So we can have a second round of the same session, sir.
Yes.
But before we wind up, sir, actually there's one more little session by Dr. Rajbir on competition that I4 Mentor Foundation has started. So
Yeah.
maybe we can hand the floor to Dr. Rajbir and then come back. Dr. Patnaik, I would request you to stay on.
I am here, ma'am. I'm here. I'll definitely
Yeah,
listen to you.
okay. Yeah, over to you, Dr. Rajbir.
Thank you so much, Dr. Sharma. Thank you, everyone. A wonderful session. Thank you, Kiran. So essentially, we are all innovators in our daily lives, but uh, there is no way to, for us to communicate to others unless we actually participate and publicly announce that this is what we're really doing. So what we thought was, why don't we actually give an opportunity to all the innovators in the hospitals who are working hard, coming up with new ideas, all the product ideas, process ideas, right? And create a contest. So the best way to kind of generate interest is to create a contest. We love to compete. We love to participate in contests. So we thought, let's create a contest. And if you're an innovator, we will shortly announce this. This will be called Innovate for Health. The whole idea is to not just to recognize, but also to create a culture of innovation. The more we innovate, more we grow, more we progress. That's the whole idea. It's a joint collaborative idea between us, I4 Mentors Foundation, and AHA. So it's not just our idea, we'll be jointly executing it. And once we announce it, we will and receive the entries, we will shortlist them and hold a proper event to recognize all the winning entries. There'll be multiple awards that will be given. I'll just share the various types of awards and what the eligibility is. So essentially, I talked about this. Why should you participate? Because it gives you a lot of peer recognition. Peer recognition is extremely important. That's what kind of builds our respect in the community. It provides us visibility, and then more visibility the idea gets, more opportunity for us to scale it and take it to the market, commercialize it. And the other reason is we will create a pool of mentors. We will actually who will help you scale the ideas, help you commercialize the idea. What should be the pricing? How to distribute it? What should be the packaging? What should be the target audience? How should you communicate those ideas? How should you raise money for that? All that support that we will provide, and we'll also try to raise money for the idea. So I have my colleague Rohit here, who actually specializes in raising money, and so what we will do is we will try and arrange funding for all the winning ideas. That's what we will do, not immediately, but once we have helped them in packaging it into a scalable model. Once we are satisfied that the model is scalable, then we will take it to the funding organizations. And so what's the criteria? Basically, it should not be just an idea stage. It should be a working model. Ideally, something has already been tested with patients or customers, internal or external. It should be innovative. It should have an impact. It should have an impact on the patient outcomes. It should clearly create an impact. Either process should get reduced, cycle time should get reduced, the throughput should improve, the cost should come down, the clinical outcome should improve. There should be very clear positive outcomes. It should be solving, and it's also important that we solve a critical problem. We can't be solving some trivial problem. Like we heard about the patent. Innovation must be must be relevant. It must be impactful. So and then it can be from anywhere in the healthcare ecosystem. It doesn't have to be just something which is being done in the OTs or in the processes, or it can be anywhere in the ecosystem. Okay, so that's the eligibility. The intent is to look at something which is meaningful and impactful. And so we'll have a lot of awards. One is these are general awards on breakthrough innovation, social impact innovation, business impact, not just social, but also business impact. Then something which can be converted into a new business. These are first 4 special awards. Then multiple other awards: patient experience, diagnostics and screening, process improvement, treatment cost reduction, improvement in the hospital throughput and efficiency, point of care solutions. Okay. And then deep digital tech solutions like clinical delivery improvement. Somebody's created new variables. Somebody's created new image-assisted interventions, data analytics, and AI-based innovations, and so on. So we are not just limited by what we can imagine today. We will identify new awards if we come up with new categories during the entire process. I hope this is of interest to all of you. And Dr. Jagtar and Dr. Sharma and the AHA organization will shortly come up with a formal announcement. And we are tying up with a couple of organizations to help you with this. So we are tying up with Microsoft to provide you assistance. If there is an AI related innovation, the Microsoft will provide mentoring and will also provide infrastructure and will also provide financial support. The other organization we are tying up with Siemens. So Siemens will also provide support for mentoring, commercialization, and go-to-market. Okay, so we are exploring more organizations, and as and when we identify more organizations, we'll share those with you. I hope it's of interest to you. If you have any questions, please feel free to ask. Dr. Sharma.
Yeah, thank you, Professor Rajbir. In fact, that's why I asked, requested Professor Saroj Patnaik to stay on, because he's head of Department of Hospital Administration at AFMC, and Armed Forces does a lot of innovations in various ways. A lot of health innovations that has emerged in the country is as a contribution of the Armed Forces, like AIMS in the country. So therefore, I just requested Sir to stay on, so that his students, he can actually bring them forth for this competition. So thank you so much. I would now hand over to Professor Hemchandra to say a few words before I propose the vote of thanks.
Thank you very much for the team I4 Mentors Foundation, Dr. Rajbir, and both the speakers basically. And much have been spoken by the Shyama and the Dr. Jagtar also. I think time is over. And whatever you have just said, Dr. Rajbir, we will discuss the matter among within the own fraternity, and we'll come back to you for. And definitely we are with you always, because we have already signed the MOU, and hopefully we will move together. Thank you very much for nice appearance and the support also. Thank you, all the delegates participating. Thank you, madam. Thank you, everybody. Namaskar.
Thank you so much.
Thank you so much,
you,
sir.
everyone.
Thank you so much, Professor Rajbir, for this session today. Thank you, Professor Soma, for conducting this. Thank you, Kiran, for such a lively presentation, a very beautifully done presentation. And I think people enjoyed it very much. Yeah, thank you so much. And as suggested by Professor Hemchandra, I think the next fortnight, the presentation, I think with due permission from Professor Rajbir and Professor Soma, can we just repeat this session again? I know there is an advanced presentation also which is there, but I would request Kiran to make this presentation again, because we may have a lot many more people joining this session. So that will be really great if she can. We have every fortnight this webinar of ours, so that others can join, and those who have got some additional queries this time may write that up and come back to you next time. So I think we'll have another session. That's from our side, a request to you. And thank you so much for to the participants. While we were very less in number today, but I saw very wonderful participation with all the members today. That is pretty encouraging. And I would like to thank the entire AHA backend team, which has made this webinar happen. And thank you very much. Thanks, everyone, and for taking out time on a Saturday afternoon. Let's meet up maybe next fortnight again with the same presentation. Only thing which will be allowed is Kiran can wear a different color of dress.
At this time,
Thank you so much, ma'am.
we will make available more and more people by giving this example of today.
Yes.
Those will be missing, those who could not join today.
Yes.
And they will really be missing this program basically. So we will give them the opportunity to come forward and have the talk from you people. This is
Yes.
interesting, I will tell you.
I would also request Kiran that, if you can break up copyright trademark as one, patents as another, because both are equally big chapters. If you can break down them and go deeper into it, it will help us, our HODs and our administrators, to pick up the topics that we can bring forth for patenting through AHA and I4 Mentor Group. So just to answer Major Asim, so Major Asim, we have a partnership with I4 Mentor Group. So you don't have to look far for a copywriting support. So we can help you for getting the patents and the copyright and everything done. Of course, for a nominal charge, we won't do it for free of cost. We have to run our back-end administration. That's all. Thank you so much.
Thank you so much, ma'am.
Thank you very much. Thank you. Namaskar.
Yeah.
Thank you, madam.
Thank you. Thank you so much. Thank you very
Thank
much.
you. Thank you, sir.
Bye-bye.